All right, I have 3 files here. I have 2 civil infractions, 1 misdemeanor case. Misdemeanor file is 25F00373ON. People in the city of Burton was Christopher Allen Renfro, and then the 2 civil infractions, 25F00141OI and 25F00394OI. People of the city of Burton versus Christopher Allen Renfro. And turn on that.
All right, here we go. This might look like a routine pretrial, but don't blink, because what's about to happen is a textbook courtroom meltdown. The defendant is about to challenge the entire legal system, and trust me, it does not go how he expects.
Jury trial day, as my associate has indicated that Ms. Jones is not thinking and is not inclined to accept any sort of offer.
All right, thank you for that. And then Ms. Renfro, you can go ahead and state your name for the record.
My name is Christopher Allen Renfro. Today I am demanding a vacate of these matters, for I still do not consent. The jury trial is not a grand jury, so.
Okay, pause right there. This is where things start going off the rails. He's mixing real legal terms with completely misunderstood concepts. A jury trial versus grand jury argument? That's already a major red flag. Do you think he actually understands the law? Or is this about to backfire?
Was vacated also. No, there was no proof nor burden that the testimony of the cop was true, and also no evidence. I still have not gotten discovery, which means it doesn't sound like plaintiff is ready to move forward either. So that's my statement. I demand the court to vacate these matters and restore them whole again.
And just like that, reality hits. The judge wastes 0 time shutting it down. This is something you'll see often in court. Confidence means nothing without correct legal grounding. One wrong argument can collapse your entire case in seconds.
What you want to talk about is the discovery issue. And so is there any discovery that Mr. Renfro makes that he does not have?
There's a police report in the criminal matter and then the tickets that he received.
Has that been provided?
I have no way to provide that to Mr. Renfro. He offered it to them previously and did not take that.
How would you like that to be given to you, sir?
Well, the 24th was the cutoff, so we're past the cutoff. And that means that there's no discovery on either side.
Well,
Now this is a powerful moment. The judge is making it crystal clear courtroom procedure isn't optional. You don't get to opt out of a system just because you disagree with it. Question is the defendant realizing this yet, or is he about to double down?
discovery, how do you want to indicate?
I don't. We're past the cutoff line, and I want to vacate.
He doesn't want it. Well, if you don't want discovery, that's fine. In regards to work, also I want to mention, not right, but somewhat maybe along the path towards that somewhere. When you say that the thing about the civil infractions, so you're right, civil infractions are not criminal matters. They are civil infractions for a reason because they don't carry any penalty of going to jail or anything like that. And so you are entitled to a jury trial on the civil infractions. You are entitled to a formal hearing. So my plan would be to have the formal hearings either before or after, depending on how it works out, the jury trial on the misdemeanor matter. Attorney Odette, do you have any objection to that?
I have none, thank you.
All right, and Mr. Renfro, I know you don't want to be here, you don't want to do any of this, you don't consent to anything, but nobody here on a criminal case really consents to it. So is that all right if we do those things at the same time, or would you prefer to come back on different days?
Consent comes from the Declaration of Independence. Their second paragraph down talks about the consent to be governed, and also William Lynch letters talks about when slavery ended or commerce was created. What differentiated the two was consent. So maybe we need to go back to our books.
That is a very interesting concept. And again, incorrect. Also, Declaration of Independence is a law. Declaration of Independence was a declaration that we made to the King of England about what we wanted to see happen in this country. So that's not law. I wouldn't quote that anymore. I would
The
quote
reasons why
other
they went to
things.
war with England.
One more
was
time.
Sam in America.
Don't interrupt each other. We're going to keep doing this, and I'm going to keep reminding you of that, because if you try to do it while we're having a jury trial, I'm going to shut it down way faster, because we're not going to do it in front of a jury. All right? So, again, remember, we don't interrupt each other. So let's go back to the question, which was, would you like to do the jury trial and the formals on the civil infractions on the same day, or would you like to do them on different days? That's the only answer I need right now.
Proceed how you feel, because you already have, so.
Okay, I agree with that. So we will set them for the same day. I think that would be more convenient for everyone involved, and
Young.
we do try to be convenient for people around here. Okay, and so let's set this then for.
I believe it's already set. I believe we're going to for we're going to go to buy something.
But it was not set. If we set this for August 7th, Mr. Renfro, is that an acceptable? I know no date is acceptable to you, but are you free on August 7th?
Promise, I'll be here.
Okay. All right, you'll get a notice. We won't send any summons, but we will send a notice for you.
Only someone's gonna send me there.
Well, if you don't show up, I'm going to issue my score for your arrest. So be fair warned. August 7th, jury trial, 2025, August 7th at 8:30 a.m. That will also be the same date for the formal hearings on the civil infractions. And like I said, I'm not real sure which ones we'll do first or last, but I'm thinking we'll probably do the jury trial first so we can get the jury in and out of here, and then we'll move on to the civil infractions. That way, if we have to come back the next day on the civil infractions, we have to bring jury back. Last thing before we leave, Attorney O'Donnell, you mentioned that, actually there's two more things I want to talk about before they one. You mentioned that today was set for pre-trial and motion, and I do have as well have it that there's no stuff for motions, but I don't have any written motions filed. Did either of you file any written motions?
I did not, Your Honor.
Did you? Mr. Renfro?
No, I do not.
No? Okay. All right. So I don't know why that was set for that. I know you made an oral today. All right. Well, then that's not an issue. I will also note that right now the jury trial actually has a date for Friday, September 5th.
Yes, that was the day that was the movement.
This is the date for Mr. Vacate.
Okay.
And we are virtually instead of doing
Gotcha.
and it just happened when we walked.
Gotcha. All right. So do you want to do August 7th or September 5th? Let's say either day. It's going to be fine.
Well, and of course, especially.
I'd say August 7th is good days any, so we're gonna we had it originally set for we had the July 25th. We had to move it if there was some kind of notice here. Maybe I don't remember what happened that day, but it was something weird. So then we moved it, but we'll move it back to August 7th. That way we can get Mr. Renfro in a little bit sooner rather than later. I think those are all the things that I wanted to cover, except one more time, Mr. Renfro. I know we've already talked about this, but it is your intention to represent yourself in this matter. Is that true?
It ain't my intention to present this cause.
Okay. You do not want me to ask the public defender's office to appoint you an attorney. Is that right? You don't want that, right?
No.
And you do not want to retain an attorney. Is that right?
Right, I'm competent. I will see if it matters to myself.
All right, you understand, I know we've talked about this before, but you understand that Attorney O'Donnell and the people that work in our office that are lawyers have law degrees. They've been through law school. They've been doing this for many years. And according to the people in the legal system.
And here it is, the final warning. Representing yourself might sound empowering, but in reality, it's one of the biggest risks you can take in court. No legal training, no strategy, no safety net. So what do you think? Confidence or overconfidence? Because the outcome of this trial might depend on that one difference.
As we all respect each other and respect this room, everything will be fine and you can represent yourself. I don't have a problem with that. But if we start crossing those lines, that's when we're gonna have problems. Okay? All right, I think that's it for today. Thank you.
May I approach the fire circle for consideration?
We're living on this.